Science Uncut, presented by the Volkswagen Foundation.
We do not live in societies that are shaped around just one or perhaps two religions. We live in a religiously diverse world, and this creates challenges. There is a standard answer to the question of how we can meet these challenges, namely state neutrality and secular law. Secular law is our mechanism to resolve religious conflicts and to achieve peaceful religious coexistence. But it's not that simple, says Matthias Koenig. Koenig is a sociologist of law. He's professor at the University of Göttingen and fellow at the Max Planck Institute for the Study of Religious and Ethnic Diversity. In his talk, he argues that there are two main problems with our standard answer to the question of how to resolve problems arising from religious diversity. First, we too easily overlook the remnants of confessional statehood that are still present in our state structures. And second, we have to pay more attention to the limitations of secular law and to how it operates. How is religious diversity actually governed? To answer this question, Matthias Koenig takes a closer look at the ways the European Court of Human Rights in Strasbourg has affected national and transnational laws and structures over the past 20 years. Matthias Koenig's talk has the title Governance of Religious Diversity, Socio-Legal Dynamics in Europe. He gave his talk on October 5, 2016 in Hanover at the Herrenhausen Conference, Religious Pluralization, a Challenge for Modern Societies. The conference was organized by the Volkswagen Foundation.
It's a great pleasure for me to be here to speak on a topic which is evidently of wide general public as well as academic importance, the challenge of religious diversity. And I've been attending several conferences devoted to this theme, and what strikes me as quite distinctive of this setting is the absence of lawyers on the topic. Typically, you would find at least half of the people coming to this question from a legal point of view, and this is basically what I will be doing today, speaking not as a lawyer, but as a sociologist of law who takes a more social science perspective to the role of law in governing religious diversity. So let me just repeat the general rationale of this conference and also of the talk, which is evidently related to the challenge of religious diversity in Europe. We've yesterday started discussing some of the large trends that are in the backdrop of these challenges: declining church membership, previously called secularization, religious individualization, and above all, migration-driven processes of religious diversification. When talking about the broad patterns of religious diversity, it also was clear yesterday that religious diversity is not simply a diversity of various confessions, as we had it perhaps in the confessional age, but that religious diversity is inherently linked to the global power gaps out of which current processes of migration are driven, that they are related to questions of political exclusion, access to citizenship, etc., and above all to questions of social inequality. This is the background against which the contemporary conflicts over the public recognition of religious difference are to be understood. And as I already indicated, there is a standard answer to the question how to respond to these challenges. The standard answer would be something like this. In modern societies, we have found a mode of integration that allows for coexistence in religiously diverse societies, which is secular law. The emergence of secular law as a distinctive domain is typically regarded as an achievement of processes of differentiation, and henceforth, secular law operates as a mechanism of conflict resolution, which allows for the accommodation of different religious worldviews and needs. Religious freedom and state neutrality in particular are regarded as legal principles that allow for a peaceful governance of religious diversity. Now, this standard answer, which I think is lingering around still in the debate, has a number of problems. First, it fails to identify the remnants of confessional statehood in Europe, and second, it provides a highly idealized or normative account of social-legal dynamics in the European context, and I will briefly comment on both of these problems. Starting with the first problem, it is well known from comparative research, going back to the work of David Martin and continuing in the more recent comparative politics literature, that confessional statehood, the Westphalian model, has left remnants in contemporary European nation states. State structures are tailored to monopolistic or duopolistic religious fields, and national identities continue to be impregnated by confessional or religious components. Just as a brief snapshot, you see here data from the International Social Survey Project, drawing on the question where respondents are asked to answer the question to what extent the religious majority is an important element for belonging to the nation. And you see that the ranges vary substantially, with some European countries having considerably above half of the population supporting the view that belonging to Catholicism or to Christianity more broadly is part of what national identity means. Against the backdrop of these state structures and national identities, we see a huge variety of church-state relations, which already complicate the standard view of secular law as a conflict-resolving mechanism. We have separation regimes, as in France, we heard about that yesterday. We have cooperation regimes, as in Germany, and a number of countries with official and national churches. It is against this backdrop of the remnants of confessional statehood that the contemporary conflicts over religious diversity challenge the institutional arrangements of state, nation, and religion. And this is the first problem of the standard account of secular law being the answer to the challenge of religious diversity. But there is a second problem, and that is the problem on which I want to focus in this talk, and it is related to the view of how law actually operates. The question we need to ask more explicitly is what the social-legal dynamics empirically are in the way that religious diversity is governed. Do they change institutional arrangements of state, nation, and religion, and if so, in what way? And the argument that I want to present in a nutshell is something like this. The judicial politics of religious diversity that we have seen in the past 20 years contribute to institutional change in a twofold manner. They contribute to a demonopolization of the religious field, but paradoxically, they also contribute to a re-regulation of the religious field. I will elaborate this argument in 3 steps. I start with some theoretical background from the law and society literature on how to understand contemporary judicial politics. I will then focus on the European Court of Human Rights as an arena of negotiating religious differences, talking about the way that religious groups litigate in Strasbourg, how the court responds and establishes itself as a secularizing agent, and how it produces effects for the various domestic institutional arrangements of state, nation, and religion. And then I conclude with some thoughts on the ambivalence of secular law. Now, when we think about the role of law, it is apparent that in the 20th century, the role of law has considerably changed due to the global rise of constitutionalism and human rights. We see across the globe a diffusion of rights provisions in constitutional law, in international law as well. We also see an expansion of the field of transnational law, including human rights law, and we see a notable rise to power of constitutional and international courts as political players which adjudicate on major political decisions. These processes have been captured under the notion of judicialization in the law and society literature, and this judicialization also applies to the way that religious governance is occurring in the contemporary period. Courts are the key institutional arena for negotiating religious differences, for conducting the conflicts over religious diversity. Now, what are the effects of judicialization? There are basically 2 opposing views in the law and society literature on this. The first can be captured as the notion of the judicialization from below, and the other one as a judicialization from above. The judicialization from below view is, as it were, the optimistic vision of law as a means for suppressed minorities to articulate rights and to oppose political majorities. The judicialization from above view is a little bit more pessimistic because it argues that the delegation of power away from the democratic politics to the courtroom is a strategy of elite interest to safeguard their inherent preferences. Now, in my own work, I take sort of a middle road. I would argue that both effects are simultaneously occurring and that we see these effects if we conceive of the judicial politics as a field with various actors that are including both minorities and elites that struggle over the interpretation of basic human rights norms. Now, if we take such a view, we can formulate a very brief process model of judicial field dynamics in which we would first have to analyze litigation patterns. Here, the core argument in the following will be that the relative autonomy of judicial fields increases the opportunities for the mobilization of religious minorities. So that is sort of where the judicialization from below comes in. The case law and jurisprudence step then would argue that the minority litigation provides occasions for courts to continuously reinterpret notions of religious freedom and state neutrality. And then finally, in this process model, we need to take into account the policy repercussions of case law, in which courts, in dialogue with public policies, contribute to incremental institutional change in the governance of religious diversity. And it is this process that I will try to disentangle a little bit in the following, focusing on the Strasbourg Court of Human Rights. Now, first, as a very brief comment on historical background, I would like to remind you that the European human rights regime is far from being designed in the 1950s as a response to religious diversity. To the contrary, the human rights regime and the notions of religious freedom are designed as part of the Christian democratic process of reinventing Europe on the premises of basically Christian majority culture. This has been shown in the historiographical research on human rights regimes. It is obvious from the highly symbolic function of the European Convention of Human Rights, where all member states assume that this would not alter their domestic policies at all. It's basically a symbol to the communist world of what the main anti-totalitarian values of European democracy should be. The provisions on religious freedom and non-discrimination in particular, that is Articles 9 and 14 of the European Convention of Human Rights, were highly inspired by the personalist strand of the new Catholic natural law thinking of the 1940s and were explicitly seen as being compatible with official churches. So the notion of religious freedom, as it was understood then, was basically a view to allow for the expression of majority religious cultures and for maintaining the entrenched situation of majority churches in European countries. This is reflected in this immediate post-war period in the margin of appreciation doctrine, in which each country is basically free to design its own interpretation, its own institutional implementation of religious freedom provisions. As a consequence, the jurisprudence of the court until the 1990s was highly status quo oriented. It did not touch upon church-state relations whatsoever. One example that I often like to cite in this context is a famous case still from the early 90s, Otto Preminger Institute versus Austria. This is a case which juxtaposes free speech claimant to the Catholic majority of Tyrol. And you can read here, the court cannot disregard the fact that the Roman Catholic religion is the religion of the overwhelming majority of Tyrolians. This was a blasphemy case, so the film, Das Liebeskonzil, that was seized, and in doing so, the Austrian authorities acted to ensure religious peace in that region and to prevent that some people should feel the object of attacks on their religious beliefs in an unwarranted and offensive manner. And then the margin of appreciation doctrine is cited as a rationale for allowing Austria to support the restriction of free speech vis-à-vis an anti-Catholic film. Now, this changed, however, in the post-Cold War period, and there are a number of reasons for this. There's first of all a proliferation of human rights INGOs that already starts in the 1970s. There is also the institutional reform of the Strasbourg Court, with the new member states of Eastern Europe entering the European Convention of Human Rights, and thus calling for a refinement of the judicial machinery. And as a consequence, we see an expansion and increased autonomy of the transnational judicial field, which allows the court to become more activist and more reform-oriented in its jurisprudence concerning religion-state relations. Now, in the following, I focus on precisely that period of the post-Cold War times, and I want to argue that in various steps, as I laid out in the process model of judicial politics of religious diversity, we see the increasing role of the court as motor of institutional change. It starts all with the religious litigation at the Strasbourg Court. We see an exponential increase in religious minority litigation since the 1990s, notably among minorities that are highly transnationally interconnected and connected to the culture wars in the US, including evangelicals and Pentecostals, but evidently we also see the presence of migration-related minority groups. In addition to the increase in religious minority litigation, we also see a substantial presence of third-party interveners in Strasbourg, including religious lobby groups and law firms such as the European Center for Law and Justice, which is an offspin of an American-based law firm advocating for the Christian right. On the opposite end, we see human rights NGOs, Helsinki Monitor, Open Society Foundation, which basically promote the anti-discrimination agenda of these human rights lobbyists. You see here, which is based on comprehensive research on the case law of the Strasbourg Court on religion-related cases, this increase in religious litigation. And on the left side, you see the amount of cases coming to the court in the 30 years between the foundation of the court, 1959 and 1989, without any violation of Article 9 being found. And then you see the enormous increase of religious litigation after 1990, and also the appearance of a number of violations of Article 9 being found by the Strasbourg Court. Now, how did the Strasbourg Court become a motor of secularization, of state secularization, as it were? There are three steps that I want to highlight here. The first, which is to be found in the 1990s, is basically an attempt to establish judicial authority on religious freedom interpretations vis-à-vis the domestic constitutional courts. This is found mostly in case law concerning Article 9 violations, for instance, related to proselytism, conscientious objection, registration issues in Orthodox countries with official churches. The first case, Kokkinakis versus Greece, well known from 1993, sets the agenda for the court being more activist on religious freedom, and is repeated in subsequent case law on Greece, Bulgaria, Russia, and other countries with official churches. So what the court does here is it claims authority to enforce religious freedom, and it does so by attacking those countries with the official state, with the official religion regimes. In this chart, you basically see the pattern quite clearly. First of all, you see that the new member states, even though they have lower numbers of applications to Strasbourg, that is, of claims being made in Strasbourg, have a relatively high level of being found in violation of Article 9, and this is repeated when you look at the Orthodox pattern or at the pattern of official religion. So that is basically where the court starts, and over time, and this is the point that I want to highlight in the following, it develops authority also to intervene in institutional arrangements, in cooperation regimes, and in separation regimes. This is done in a second step, which is related to the case law concerning Islamic claims, where legal schemas of religious pluralism are crafted and promoted. The key body of case law here is the number of judgments in response to Muslim cases, notably headscarf cases from Turkey, Switzerland, and France. And the basic line of argumentation is developed in the political party prohibition case, Refa versus Turkey from 1998, where the court accepts the position of the Turkish state as seeing secularism, Kemalist secularism, as a defense of democratic society, basic normative notion in the court's jurisprudence, and as a necessary defense against putatively anti-pluralist forces such as Islamic political parties. That is, a notion of pluralism is developed here in which pluralism needs to be defended against the anti-pluralists, including extreme religion. This line of argumentation is then subsequently used in a number of cases concerning headscarves, and most recently in the SAS case concerning the full face veil, about which we heard yesterday already. What the court does here is that it defends secularism as understood in the Turkish and in the French constitutional tradition as a legitimate protection of pluralism and of living together. These are the notions used by the court. The third step I skipped this here for reasons of time. The third step in the process of becoming a secularizing agent is the attempt to standardize judicial dealings with Article 9, 14, and Protocol 1-2 cases in member states with corporatist and secularist church-state relations. The main areas where this is done concerns obligatory religious oaths that are seen as violating religious freedom, obligatory religious education, where the court develops a very clear position about the state being prohibited of endorsing any form of religious indoctrination, and also in the case law on the registration of religious associations, where countries such as Austria, but also Hungary and Russia are repeatedly found in violating the rights of religious minorities. The key test of the limits, how far the court can go in changing existing institutional arrangements of state, nation, and religion, is clearly the Lauzi case on crucifixes in Italian public schools. This was a case which, in the first instance, in the chamber decision, was going all the way in the secularist direction, and its emphasis of state neutrality. And I want to quote from this decision very briefly. The court considers that the compulsory display of a symbol of a particular faith in the exercise of public authority in relation to specific situations subject to governmental supervision, particularly in classrooms, restricts the rights of parents to educate their children in conformity with their convictions and the right of school children to believe or not to believe. It is of the opinion that the practice infringes those rights because the restrictions are incompatible with the state's duty to respect neutrality in the exercise of public authority, particularly in the field of education. So this is basically how the court operates very much in conformance with the standard account of secular law. But evidently, this was not the last word, because this first judgment produced a huge counter-mobilization of Catholic states, of Catholic lawyer associations, of various governments, of the European Parliament. And as a result, the court had to change its view in the Grand Chamber decision, thus allowing the Italian state to continue displaying crucifixes in public schools. This brings me to the effects of the case law of a human rights court. There are evidently a number of direct effects that have changed the institutional arrangements across European territories through asking the countries to adopt individual remedies or general legislative measures to bring their own legislation in conformity with the European Convention of Human Rights. This has happened in Greece, in Moldova, in Norway, in Turkey, a number of countries. More importantly, I think the huge public visibility of the Strasbourg Court within the national legal fields has produced new schemas of perception and repertoires of action, both for religious minorities claiming public recognition and for state authorities in governing religious diversity. That is, if you look at the SAS decision, for instance, this was seen basically as a carte blanche for other governments to restrict the full face veil as well. So the court, in a way, operates as a producer of the legal schemas of arguing about religious diversity, which have effects across the European space. Finally, I want to highlight the paradoxical effects of the ECTHR case law, which are very much evident in the counter-mobilization against Laozi, but also in other cases. The liberal thrust of the ECTHR jurisprudence continuously produces reaffirmations of majoritarian identities that evidently are captured by party politics in the various national arenas, and therefore lead to much more ambivalent and paradoxical changes than the standard view of the role of secular law would typically suggest. So let me conclude. What I tried to argue here is that using the Strasbourg Court of Human Rights as an example of a high-profile human rights court, we see that the role of judicial politics as a motor of institutional change has been very prominent, but that the effects of the judicial politics of religious diversity are highly ambivalent. On the one hand, they lead to a demonopolization of religious fields, a downscaling of privileges of religious majorities. At the same time, given the prominence of notions of secularism, a certain interpretation of pluralism, and of living together in the court's jurisprudence, they also allow for a re-regulation of religious fields. This evidently has highly ambivalent consequences for minority accommodation. And this brings me to the last line of considerations. When reflecting about responses to religious diversity, it seems to me that instead of reproducing the standard narrative of secular law as and religious freedom and state neutrality as means of achieving peaceful religious coexistence, we need to be more aware of the limitations of secular law. This has to do with asymmetric opportunity structures for religious legal mobilization that can be observed in the Strasbourg Court. It has to do with the judicial restraint in resolving highly politicized conflicts, as the Laozi example attests. And it suggests that we need to pay more attention to alternative arenas for governing religious diversity, and thus to engage in a much more complex analysis of the multiple modalities of governing religious diversity in Europe. Thank you.